Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law, and today's guest is Todd Berger. He is at Syracuse Law and serves as the Director of Advocacy Programs and the Director of the Law School's Joint JD LL.M in Advocacy and Litigation. He also hosts the American Bar Association's Law Student Podcast. So welcome, Professor Berger.
Thank you very much, Dean Roberts. It's great to be here. I really look forward to talking.
Well, it's always weird, isn't it, being a podcast guest when you are a podcast host? But I'm going to try to make this easy on you nonetheless. So you have been at Syracuse since 2012, and you were not a professor before you joined Syracuse College of Law. Is that correct? What did you do before then?
So after I graduated from law school, I worked as a public defender in Philadelphia for 7 years. And during that time, I got an opportunity to teach a clinic. It's really interesting. In Philadelphia, the criminal defense clinics for all the Philadelphia law schools are all run through the public defender's office. It's almost like a hybrid.
Interesting.
It is. It was fascinating. It was really like, I didn't realize any of this at the time because I was just sort of teaching and, just work. I wasn't thinking about a career in academia, but they're kind of hybrid clinic externships. So it's not really an externship model. It's a class. You're teaching it. You're responsible for all of these different students who are signed up for a clinic. And so it's a little bit different than what you might see in an externship, but it's not an in-house clinic. It was like out in the actual public defender's office with the real public defender's clients. So I was there for 7 years, and 5 years into it, I got an opportunity to teach the clinic at the University of Pennsylvania. And I realized like, oh, this is what I want to do. If I can practice and teach at the same time, this is a dream job. So I was then able to leave after 7 years, not able to leave. I wasn't like trapped or anything, but I got an opportunity to leave. And I went to Rutgers Law School in Camden, where I started a prisoner reentry project, which had a clinical component and had a pro bono component. But I missed kind of what I would call like the front end of criminal defense work. So actually working with clients who are in the criminal justice system. And I also wanted to sort of teach outside the clinic too. And I got that opportunity at Syracuse. So came up here. I think this is my 13th year here, and directed the criminal defense clinic for 7 years. And I've been in the advocacy role for 7 years. There's a year overlap, and get to do this and teach outside of the advocacy program as well. So it's been great.
That's a lot of robust experience to bring to clinics. Are you still teaching in the criminal defense clinic?
I'm not. So I consider myself like ex officio, the criminal defense clinic. I don't know that anyone else considers me that, but I still consider myself a clinician. I still consider myself a practicing lawyer, although I don't do that often. But I work with the head of our criminal defense clinic now here and there, and we talk about cases, and he's terrific. But I just I keep my office in the clinic because psychologically I can't move beyond the idea of being a clinician, even though I don't do that anymore. So
that's
I'm
so
not
funny.
Really a clinician, although sometimes I play one on podcasts.
Well, once a clinician, always a clinician. That's the way I feel anyway. But how cool that you have enough real estate at Syracuse Law that you can keep an office in the clinic. So good for you.
Yeah, I sort of refuse to leave. It makes it awkward to get evicted. We'll see what happens.
Well, one of the things I want to talk about today is not just your programs at Syracuse, which I do want to cover, but you have a book that's coming out through Aspen called Comprehensive Criminal Procedure in Focus, first edition. And I understand that this is not your only foray into writing for Aspen. So tell me a little bit about your criminal procedure publications.
So it's been going on. I think I wrote in the acknowledgement section of the comprehensive book. I counted up like the number of days that I've been writing these books for Aspen since I got the initial contract. I think it's like 9,000 days or something like that. This has been a big part of my life because I've done it, all by myself. Basically, I haven't had a co-author, so I would say it took double the amount of time, but it probably took a lot longer than that. But I first decided I was going to write criminal procedure casebook. But as your listeners know, you can take criminal procedure and you can teach in a couple different ways. So it's most commonly taught by separating out two areas, by separating out investigative criminal procedure, which is usually a study of like how crime is investigated. So a lot of Fourth Amendment stuff, confession issues, identification issues. And then the second part of that is adjudicative criminal procedures, all your trial and bail rights. So the investigative, sometimes people call cops and robbers, and the adjudicative, sometimes people call bail to jail.
I love that. That's funny.
Yeah, it's kind of an easy way to keep track of what class you're teaching that day. But I was going to do comprehensive criminal procedure, but it's really a combination of investigative criminal procedure and adjudicative criminal procedure. So You can buy I started writing with Aspen a long time ago, and I wrote an investigative criminal procedure book, and then just recently wrote the adjudicative criminal procedure book. So both of them are out. You can buy them as separates, as they kind of call them. So investigative criminal procedure and focus, adjudicative criminal procedure and focus. Or if you're a school that teaches them in a combined class, or you're going to use the same book for both classes. If you're a professor and you want to teach both classes and you want to stick with the same book, you can use the comprehensive criminal procedure and focus, which is just investigative and adjudicative combined. But all told, doing all that myself, Fred, I mean, it goes back to like the Obama administration.
Well, 9,000 days, that's a long time. But congratulations. So here you are at the finish line, and the comprehensive criminal procedure and focus book is coming out. Would these courses always be split? Is there ever a scenario where the cops and robbers and bail to jail are in the same semester?
Yeah, absolutely. And some schools do that. They'll kind of teach a survey version of criminal procedure, and then they just have to figure out how much of each class they want to cover. So I've kind of looked at some of those models, and obviously it depends on the professor and what they think are important. But you're usually, if you do the survey style, I mean, it depends where you are, but usually rather than a 3 credit class, it's a 4 credit class.
Yeah.
And it usually gets like 3 credits of investigative and a credit of adjudicative, give or take here or there, how you want to do it. So you could definitely do it all in one course.
So besides the fact that this covers investigative fully and also adjudicated, what are other reasons faculty should consider using your book?
Yeah, so this is a great question, right? That's maybe like the most important question if you're out there and you're hearing this and you're thinking about adopting a criminal procedure book. So I think that in a lot of ways, I'm writing in the In Focus series, which some people may be familiar with. And the general idea of the In Focus series is that it's sort of more author written text, more directive than a traditional hide the ball case book, and a lot of problems built into test the material. So that kind of general format really worked well for me because I think in a lot of ways, and I don't think I'm unique in this sense. I think it kind of mirrored how I taught and how I teach. So when I became a law professor, I think I had this idea in mind that I was going to emulate what it meant to be a law professor, which was like the wicked use of the Socratic method. And that just doesn't exactly work for me in a lot of ways. I mean, it's not, I engage with the students and I ask the students questions, but I'm definitely not a hardcore Socratic method style teacher. So one thing that I think this book does pretty well is it uses fewer cases, but there are definitely cases and a lot of author written text. And so it kind of, I think, works if you're having a style of teaching that is sort of less, let me hide the ball and then gradually show the students, and a little bit more directed with the material, and then relying more on the problems to draw out the student's understanding of the material itself. So what I saw happening here and there is that there are different professors who I think got away from the traditional like casebook style, and they started to use almost like horn books. And sometimes when I would prep for classes, I would use different treatises. I like to think of this book in the In Focus series kind of a combination of a student-focused treatise with cases involved in it. So it's kind of a combination of a treatise and a case book in a lot of ways, and kind of melds those two approaches. And then at the end of it, there's a lot of questions. So if you're the professor who likes to throw out hypotheticals that aren't designed to like mess with the students, but hypotheticals that are designed to let the students test their knowledge based on what they've read and see if they understand it, maybe dig a little bit deeper, but still with the base of knowledge they have, then I think it's a good book. So it can work with that kind of teaching style pretty well.
Well, and I would think, just as you describe it, kind of more directive, less aha, gotcha, kind of, no, that's not what I'm looking for here, that kind of thing. And having more time and problems for application, that seems to me more attuned to what I see in the learners of today. I think,
Yeah.
is that what you're finding, that the students react better and perhaps learn the material more effectively because of this approach?
Yeah, 100%. So I think that, it's a really good point is, when I was talking to Aspen about the idea, it was kind of the idea was they were trying to create something that they thought would work with a new generation of sort of learners. And I think that's 100% true, is that, this generation, they're not as involved in want to be as involved in let's do hide the ball, let's do the kind of Socratic method thing. I don't know that, one, I think to teach like that, I think you have to it's beautiful when you see it done well. It is so hard to do well. And I think that sometimes students struggle with that. And I think that they want more kind of like directed learning. And the reality of it is that the students can learn the law and learn to think like the law if the presentation is more directed. At the same time, I think that, you just rather than just get up there like an undergrad lecture, like there's ways to engage with the material that is directed, that's not hiding the ball, and is still involving the students in the material itself, still having them talk about the cases, pull out the rules, asking them different questions from cases. And so I think that this generation of students definitely, and maybe older generations of students would have preferred that too. It just wasn't an option. But I think this
That's right.
generation, it's like you had Kingsfield, and right, that was it. But this generation of students, I think that does respond that way. And I've used versions of my own case book material forever because I was just like, I would just send out the students to Word documents. I told them, this is going to blow up one day, and you're going to be able to say, like, I was listening to this band and when they were playing in the garage. So I would give them those versions of it, and it always worked. I mean, the students, I never found the students didn't understand it or they weren't engaged. I think that they actually appreciated the fact that they understood the material and came to class a little bit more prepared to delve deeper with it and engage with it and ask questions, as opposed to just like read the book and think, like, what kind of happened? Like, I think I got it, but not really. And then you have to spend a lot of time just kind of explaining the fundamentals to the students.
Well, so it's had the benefit of like 9,000 days of student feedback and interactive work with it. So that it's got to be fantastic. But I think, you're really onto something. And I'm assuming the rest of the In Focus series is also trying to do this, because at the end of the day, we don't want them to regurgitate the rules that they might have finally pulled out from that discussion that is traditionally Socratic and dives deep in the way that our professors decades ago were able to do. We want them to play with it, right? We want them
Yeah.
to see what it would be like with 10 different scenarios. We want them to apply it. It sounds like that's what you're giving them the opportunity and more time to do if it's more
Yeah.
directive.
Yeah, absolutely. It's just think about the law, kind of apply it in these different scenarios and think through whether it makes sense based on those different scenarios. And you have the opportunity to do that because the style is designed not to hide the ball and to be accessible, which is some feedback I've gotten from students, which is great. And so they come prepared, having that foundation to be able to then start to play with it in different scenarios. And you can also get into the policy stuff too by saying, well, does this part of the decision make sense? Does that part of the decision make sense compared to these other things that you might be thinking about or other Supreme Court decisions? But if the students don't even understand the decision in the first place, they can't start figuring out how it does or doesn't relate to other cases that might be out there. So that helps the conversation go a little bit deeper. So in a certain sense, there's kind of an irony to it. It's like the more directed you are at first, the deeper it allows you to get later and play with different scenarios and more complex issues. And then just using the approach in class for a number of years, I found that to be the case. And I think one thing about Syracuse that's really interesting is to teach here, I think you have, and have engaging classes, you have to have a unique approach, but you have to have a particular approach that allows you to teach to a broad range of students. And I don't think Syracuse itself is unique in that regard. I think there's probably 100 law schools that are like that, right? We have students at the top of our class that could go to the most elite law schools in the country and do well. We have students at the bottom of the class who struggle and are going to probably struggle when it comes to taking the bar exam. And we have students who are in the middle of our class who are there for different reasons. And so to have an engaging, accessible class, in one class, you have to teach the students who could do well at the country's best law school and students who are going to struggle. And so I think this book gives you at least the way I've written it, and I think the feedback I've gotten, it gives you the ability to have the material be accessible to those students at one end, and at the same time gives you opportunities to build on it where it's engaging enough to the students at the other end.
That sounds wildly successful then. Now, if you're thinking about these last 9,000 days and from when you started the investigative book to now when you have the comprehensive book finished, what are the biggest changes in criminal procedure law that you have had to incorporate or wrestle with?
It's a really good question. So it's funny because we'll read these cases. They're like seminal cases in American criminal procedure. And a lot of them go from like the 60s, right? So like today we were in class, I was teaching discovery, and Rick Brady is a seminal discovery case from the 60s. So you kind of look and see, Miranda or Gideon or Brady, how has the law changed? And a lot of the law is sort of, we're messing around at the edges of it because so many of the seminal cases go back to the criminal procedure evolution. But one of the things I think that has probably been the biggest change that I had to account for when I was writing the book is, I think there's been a lot of questions about search and seizure law and technology. So in particular, questions about like cell site location information, right, and using your cell phone to be able to identify where a person is at a particular time. I think there's also been a lot of questions that have come up that are related to that about how like poll cameras that could just stay up on a poll forever that 4 was impossible. Automatic license plate readers, all of which can allow you to track someone constantly. So I think these questions of like geolocation and technology in the Fourth Amendment has really been this emerging area that you can have to adjust to, and you have to sort of figure out the technology piece of it while you're writing this book. So it kind of forces you to be able to not just understand the law, but understand a little bit of the technology as well. And I imagine that that's increasingly only going to be more of an issue in the future than less of an issue.
Well, it's the issue I would have expected that you would
Yeah.
have brought up an answer to that question. But recently, I just can't believe, I think it was in the UK, that the UK wants Apple to just, unencrypt any phone anytime. And I was like, what in the world? But it's changing so quickly, all of this technology stuff related to criminal investigation. So I imagine it will keep you busy with updates.
Yes, absolutely. And like, they recently, but then there's also cases like, so I wrote the book and then the Supreme Court came out with this case called Samaya, which does not deal with technology, but it deals with how you can properly redact a case where there's a confession by a non-testifying co-defendant. And so after I wrote the book, then they came out with that case and it was before I went to publication. So I had to scramble again and then I put it. So I feel like when they hand down Supreme Court decisions, they're not thinking about how it's going to impact law professors who write books. They're very inconsiderate in that regard.
No, I'm pretty sure that was not on their mind before they decided Dobbs, right?
Right. Yeah, or exactly. Or that not that it's my area, but I guess now the big issue is that administrative law case, right?
Chevron, yeah,
Which is like,
exactly.
I think people were like, well, what are we supposed to teach now, right?
I was thinking the other day, like if I were going to go back to the faculty or when I get back to the faculty, what would I teach? And I'm like, what area could the Supreme Court not just upend? Like, I don't know what that area is, but
Yep.
anyway, I don't have to think about that for a while. But congratulations again on Comprehensive Criminal Procedure and Focus First Edition that will be out later this month, February 2025.
Thank you.
Now, let's talk about your tremendous success as Director of Advocacy Programs. Your students are competing at the highest levels. I know that because you have teams competing against our own students and against our own Director of Advocacy, but you've been routinely ranked in the top 15 of trial advocacy programs in the nation. How did you start to be involved in advocacy programs? And tell us a little bit about how they operate at Syracuse.
Yeah, so I was in the clinic and so I was practicing and we were involved in trial work. And I always kind of think of the world through the prism of a trial lawyer because actually I didn't go to law school to become an academic. I went to law school so I could be a trial lawyer and I found a place to do that at the public defender's office. And so I always kind of consider myself a trial lawyer. And I went back while I was still at the public defender's office, I got an LL.M in trial advocacy. So this would have been a number of years ago, but our former dean at the time, he was our dean, and now he's our former dean and back on our faculty, Craig Boyce. He was sort of doing what deans do when they start, which is sort of looking over the institution they've inherited and kind of figuring out what parts of it work and what parts of it might be kind of the sleeping giants. And I think he kind of identified the advocacy program as an area that I wasn't involved in, but we had historically excelled. We had some really great teams that would go out there and compete. We had great structure. And so we had this really good advocacy foundation as far as intercollegiate competition was concerned. And he wanted to build on that. And we didn't have, despite the fact our teams were really excelling, we didn't have a tremendous amount of structure around the program. And he asked if I would take on this role and became the director of advocacy programs, and then sort of able to think more holistically about what we were doing from an advocacy perspective in terms of what we were doing from a curricular point of view to how our teams were competing, what educational opportunities were involved with that, how we were supporting the teams, what we were doing internally. So I think being able to, for the first time, take that foundation but build on it with having somebody whose job it was to actually do that, I think that really helped us kind of emerge as sort of this program that I think people in the advocacy community knew but didn't always have a national profile to sort of where we are now.
Well, that's really exciting. And I imagine some of that, the restructuring and the continued curricular and competitive success led to the idea of a JD LLM in advocacy and litigation, which is unusual, an unusual combo at a law school. So tell us a little bit about that.
So I have an LLM in trial advocacy that really I got when I was still practicing. And so I was always I think that was even one of the reasons it kind of made sense to ask me to do this. And I got a tremendous amount out of the LLM. So I was thinking about how could just about the possibility of offering a similar type LLM that I had that I got a lot out of. And I think it's also, there are a few programs in the country that offer one. I think it's a way to distinguish your advocacy program from other schools that are out there. So I looked around and, of those few programs, all of them were offering the LLM for after you graduate. There's some that kind of allow some of the credits you take as a JD to count, but for the most part, all of them require that you get the degree after you graduate. And of course, then they require that you pay money after you graduate. And I was thinking, what would make our offering distinctive? And I had no idea these things even existed, but across the country, there are all different kinds of joint JD LLM. So you can go and you can arrange your credits in a way where you'll get both a JD and an LLM at the same time. And I realized that, well, that was out there. That's kind of cool. There's no joint JD LLM in advocacy and litigation that's out there. Like maybe this makes sense to be the first school that can kind of do this in a way that would distinguish ourselves from other schools in the advocacy space. And so we also, thought that it would be what we could offer as students the opportunity to get this degree, but they don't have to pay extra after so they graduate. So they get 2 degrees for kind of the price of one. And so we were able to sort of pursue it and hope that it gives our students who graduate with it this really deep dive into advocacy. So they'll have a lot of foundational skills. Employers will recognize how serious they are about advocacy and wanting to be a litigator because they have this degree, and also just a way to separate us from competitors. One other thing I guess I would add to this is it's an LLM in advocacy and litigation, and I have an LLM in trial advocacy. And one of my things as the director of advocacy programs I've tried to focus on is we spend a lot of time in the advocacy world focused on trial. Like I said, I have an LLM in trial advocacy. I consider myself a trial lawyer. It's like something like 2% of all federal civil cases go to trial.
Right. Yeah.
So it's like almost every criminal case is well into the 90s resolves itself by way of a plea bargain. And so there are a lot of people engaged in litigation, but a big part of that litigation is not the actual going to trial part of it. It's the motions practice, it's the depositions that people are involved in, and certainly it's the negotiations that take place. In many civil cases now, courts have mandatory mediation, so it's the mediation. So I tried to think about the degree more broadly than trial and make it about advocacy and litigation, because the reality of it is most graduates who go into the litigation space are going to do some trial work, but most of what they do is going to be connected to these other litigation focused skills. So that's why we offered a degree that we thought more broadly captured what litigators do.
That's really brilliant. And how many courses in the degree are kind of result of the requirements for the joint LLM?
So there's 25 specific advocacy credits you have to take. So of those 25, 13 are required, or 13 credits are from 4 required courses. So evidence, and like I said, we like to think about litigation broadly. So trial practice, appellate advocacy, and alternative dispute resolution. And so 13 credits come from those 4 classes. And then the other 12 credits are from a combination of elective courses that we designate as advocacy courses that students can take. And so then students have an option to say, all right, I'm just doing the trial piece. I'm going to take advanced trial practice, jury selection, deposition, or they could do the ADR piece, right, and take mediation or arbitration or another specific negotiation class. So of those 12 credits, they can kind of choose what direction they want to go.
Have you found it to be popular?
So this is the first year we've offered it.
Okay.
So I will also say this, Patty, 6 of the credits double count towards your JD.
Okay.
So
Yeah.
it's 25 credits towards the LLM, but really students are taking 19 credits above what they need to graduate. So at Syracuse, you need 87 to graduate. So they're taking a total of 105 credits. And, it's an interesting question. Currently we have 5 students enrolled in it. We're actually a school where 10% of our student body has some version of a joint degree, because they'll take like a master's someplace else on campus. So if I look across all of those masters, the most popular ones have between like 8 to 10 students in it.
So you're pretty close for the first year.
Pretty close for the first year, exactly. And for us, it's like you could love advocacy and litigation, but you still, and I think this is okay, because you gotta, like, you don't get it for nothing. Like you still have to take 19 credits above what everyone else is taking. So it's almost like close on 2 semesters. So I kind of realized like we weren't going to have 20 students involved in it. And if we did, it's not probably rigorous enough, but it seems to be just for the first year, like right up there with the most popular degrees.
Well, thank you for sharing that. That's an exciting new new offering. I wanted to ask you, since we are both podcast hosts, you, as I mentioned, are the faculty host of the American Bar Association's Law Student Podcast. But I'm going to take it one step further because you're not just a podcast host, which many people these days can claim that. You're also a professor of podcasting. So tell me about that, because I would be surprised if there are other law schools that offer a podcasting class.
Yeah, so this is our third year offering a class that I teach called Podcasting for Lawyers and Law Students. And so my journey to podcasting professors. So I sometimes have these long drives and I would listen to a lot of podcasts on long drives. And the thing about podcasts is it's like you listen to it and you're like, this is really good, but you can do podcasts with your iPhone. So inevitably I started thinking to myself, like, if these people can do this, I can do this. Why can't I do a podcast? So it was probably one of those things where I was like well rested over the summer and had too much caffeine. I'm like, I'm going to do it. I'm going to do it. I'm going to start a podcast. So got kind of involved in podcasting in the ABA Law Student Podcast and just decided we could offer it as a class. And so this is our third year offering it. And I think for me, as far as where it situates in a law school, I think it's a couple things. So our students have to create a law-related podcast for the course. So it gives them an opportunity to pick a subject matter and delve really deeply into it as they create the podcast. So it's almost like has this, what interests you, like an independent study type thing. And this is the vehicle that they use to sort of explore that subject deeper. So they learn about the law a lot. I also like to think that, and this is one of the other things that really interests me about podcasting. So it's a vehicle to disseminate knowledge and information and engage in intellectual discussion. And so I think it's really powerful and it makes perfect sense to be situated in an academic institution for all of those reasons. But what I think is really powerful about podcasting is like if I write a law review article and I like write law review articles, no problem with writing law review articles or anything like that. But like most people don't read law review articles. Most people don't see law review articles because you have to have Westlaw or Lexis. It's behind some paywall. So whatever discussion you're trying to generate or knowledge you're trying to share, it's probably like it's going to be hard to be accessible for most people. And even if it's like on digital commons and people can find it, like the reality of most people aren't sitting around taking 40 minutes to read your law review article, but they might put their headphones in and listen to what you have to say about sentencing law while they do the dishes. So I thought it was a sort of an accessible mechanism to disseminate information and have intellectual discussion, which I really liked. And I thought it had a natural fit within higher education. The last piece of it is we actually learned the fundamentals of how to do the podcast. So I bring in other people who are experts in this area, but we have like a sound engineer come in and talk about how to get good sound. We have someone come in and explain to the students how you edit the podcast and how you publish it. And a lot of law firms have podcasts, and it's something that firms do as a way to attract clients and distinguish themselves from other firms. And so maybe this is actually the skill that our students can use when they go out there as just a marketing mechanism to be able to separate themselves from other people. And they learn the skill here. So we offer the class, 2-credit class.
That's really fun. I think that's terrific. And before we conclude, I wanted to ask you what I ask all my guests, and that is, what do you see as the future of legal education in the coming decade? Will we all have podcast courses, for instance?
Yes, maybe more podcasting. That's a possibility. So I suppose the low-hanging fruit answer is like more virtual education. So I'll try and avoid that one. So maybe I will take a contrarian view to this. So I actually think there will be changes. There's always these changes. There's always things that evolve. But I think legal education will largely stay the same. Am I allowed to say that? I don't.
You're allowed to say that. I think that's the realistic view, at least in the coming decade.
Yeah, at least in the coming decade. I mean, and I guess part of the reason I think that is that first, like law schools have been around for in some version of their current iteration for 100-something years. I don't see the students becoming, particularly in the times we live, but which are sort of very interesting times where a lot of issues are being settled in court. I don't see students being less interested in the legal system. Higher education itself has been around for like 1,000 years. And I've had sometimes the administration explain to me that like you want to change things really fast, like you have to realize it took 1,000 years to get to this point. So whatever your plan is, it can wait another semester or two. But I think the biggest reason that I found is that there's more online education, which attracts a different group of students. It's older students and they have families or jobs, and so they need to go to law school in a different way. But the bulk of people who go to law school are people in their 20s. And what do people in their 20s want? They want to be around other people in their 20s. And so, like, I don't know how it is at St. Mary's, but at Syracuse, and it's probably different at different schools, but in large, like our students have a prom. They have
Yes,
a
our students have a prom too, and they call it a prom. Yeah.
Our students call it barrister's ball, but it is like a de facto prom. And, I think that people in their 20s who aren't quite ready to jump into the professional world yet or don't want to do it, sort of, they go to graduate school, they go to law school, they're interested in it, but it becomes a social experience. And until people in their 20s stop deciding to socialize with other people in their 20s, I don't think there's going to be this wholesale change in legal education, maybe some stuff around the edges, more classes on Zoom. But I think in the next decade, you can bank on the fact there's going to be a lot of people in their 20s who want to go to law school and want to do it while being around and with other people in their 20s and going to the prom.
I think that you've put it very well in a way that I haven't heard others put it. But yes, there's that and, right? That and the online offerings that both Syracuse and St. Mary's do so that the 37-year-olds and the 47-year-olds can do the job of getting their law degree while also staying employed or being with their family or whatever it is. So yeah, and perhaps less interested in prom, right?
Yes, less
Definitely.
interested in prom, right? It's hard to go to the prom virtually. But yeah, no, definitely it's like, Brett, I guess you bring in that other segment of the students that I guess we've been missing before, which is kind of cool too.
It is cool. Great to have their perspective in the classrooms, whether they're virtual or in person. Well, I want to congratulate you again on the publication of Comprehensive Criminal Procedure in Focus First Edition through Aspen. And that includes the investigative version of the book and the adjudicated version of the criminal procedure book. You can get them separately, or you can get the one new comprehensive volume. So congratulations, and thank you for spending some time with us today.
Thank you, Patty. It's been great.
I've been a little nervous since you teach podcasting. You're probably like, I can't believe she does that as a podcaster, or why doesn't she do it this way? But I'm gonna be vulnerable and still wrap up here. But
Oh, you were great. If you were a student in the class, you would get an A for the podcast.
okay, I feel better now. Well, thank you so much, Professor Berger from Syracuse, for spending some time with us, and good luck with your book. If you've enjoyed this conversation, I hope you'll listen to additional thought leaders in legal education at where you get your favorite podcasts. Thanks for listening to Aspen Leading Edge.